Further hearing in the appeal, the Queen against Reeves Taylor.
Our apologies for getting you here at 10 o'clock and then keeping you waiting for unavoidable reasons. We will, assuming it to be necessary, and we'll be guided to some extent by Mr. Perry on this, we will be prepared to sit at 10 to 2 in order to make up the 10 minutes that we've lost this morning.
I'm very grateful, my lady. And just on the point of timing, in addition to the 3 minutes that I have left over from yesterday, as well as the half an hour for this morning, I've canvassed this with my learned friends for the respondent and the intervener. I may, with your leave, take 10 minutes from our reply time and add it onto our time this morning.
You can do whatever you like with the time you have allotted to you. It's
up
to you.
I'm very grateful, my lady. Well, in the remaining time I have then, there are 3 issues that I propose to deal with: the ICTY jurisprudence, the US jurisprudence, and some concluding remarks. Dealing first then with the ICTY jurisprudence. We submit that the ICTY was not and could not recalibrate, could not and did not seek to recalibrate the scope of UNCAT, an Article 1 in UNCAT, through its jurisprudence. It was not within its purview to do that. The ICTY has highlighted that international humanitarian law and UNCAT are 2 separate and distinct bodies of law, applicable in different circumstances, which is entirely reflected in the different elements of the crime of torture as it relates to each. With war crimes and crimes against humanity under the ICC statute and the ICC statute, torture may occur as part of an armed conflict or during the course of a widespread or systematic attack. It is that would make it a war crime or a crime against humanity. There is therefore, within that context, no need for the official capacity or the public official element. The international nature of the crime of torture within those contexts arises as a result of torture arising in an armed conflict or a widespread and systematic attack. By contrast, under UNCAT, the public official and official capacity requirement is very firmly a part of the element of the offence of torture under that regime. Now, the ICTY has recognised that UNCAT is directed at states to refrain from engaging in torture through their officials. Now, I won't go to all of those authorities. They're cited at paragraph 64 of our written case at MS 81, Memory Stick 81. In short, when the ICTY was attempting to articulate the elements of torture as a war crime in internal armed conflict, it turned to UNCAT, the UNCAT definition, to be used as an interpretational aid. And if we look at Kunerat's tab A3, tab 46, memory stick page 1378 to 1379, paragraph 482, we see that the trial chamber says this: the trial chamber is of the view that the definition of torture contained in the Torture Convention cannot be regarded as the definition of torture under customary international law, which is binding regardless of the context in which it is applied. The definition of the Torture Convention was meant to apply at the interstate level and was for that reason directed at states' obligations. The definition was also meant to apply only in the context of that convention, and only to the extent that other international instruments or national laws did not give the individual a broader or better protection. The trial chamber therefore holds that the definition of torture contained in Article 1 of the Torture Convention can only serve for present purposes as an interpretational aid. And then, of course, the trial chamber determined, as did the ICC, that the perpetrator element was not required for torture under as a war crime or crimes against humanity.
What does the tribunal mean when it says that the definition in the Torture Convention was meant to apply at an interstate level? It's creating an offence. It requires contracting states to create an offence in their own national laws.
My Lord, yes. And at the interstate level, under UNCAT, there are, of course, some provisions in relation to interstate issues, but, of course, it's relating to... we would read that respectfully as states coming together to negotiate a crime of torture within the convention, and it's at that interstate level that the states have agreed what the elements of torture should be, as they apply to them and their officials.
Is there an extradition reason why the convention might have required states to make torture a specific crime in their own laws?
My lady, yes, because of course under the convention there's the extradite or prosecute provision, so there is a need for each state to identify what the elements of torture are in accordance with the parameters of the convention in their domestic law to facilitate that provision under the convention. Respectfully, we would submit that the ICTY and particularly the Coonrach decision in relation to the elements of torture entirely makes sense, and their articulation and their extrapolation of using the UNCAT Convention as an interpretational aid only, that entirely makes sense when you consider the prohibition of torture under Common Article 3, which is what the ICTY, Common Article 3 of the Geneva Conventions, which applies an internal armed conflict, which is what the ICTY was applying under Article 3 of its statute in this case. It entirely makes sense when you consider that Common Article 3 applies to each party to a conflict, not of an international character, namely state armed forces and the armed forces of groups and persons actively participating in hostilities. That might be useful just to look at that. It's at the Intervenor Bundle tab 1, Intervenor Bundle 1 tab 4, page 33. And there we have Common Article 3, which is common to all 4 Geneva Conventions, and it provides, in the case of armed conflict not of an international character occurring in the territory of one of the high contracting parties, each party to the conflict shall be bound to apply as a minimum the following provisions. And the same arises in additional Protocol 2 to the Geneva Conventions in A4, tab 76, memory stick page 1977. Article 1 of the additional protocol, which makes the laws of armed conflict applicable in internal armed conflict, provides the scope as to who the additional protocol will apply to. And we see there that it shall apply to all armed conflicts in the territory of a high contracting party between its armed forces and dissident armed forces or other organised groups which, under responsible command, exercise such control over part of its territory to enable them to carry out sustained and concerted military operations. Now, as I've stated
So what was
already,
the page reference to that?
memory stick page 1977.
1977.
1977 coincides with the year of additional protocol 2. The ICTY was using the UNCAT definition as an interpretive guide for the elements within those contexts under Common Article 3 and Additional Protocol 2. It was not, as we've stated already, seeking to recalibrate what the UNCAT scope or definition should be under UNCAT, and nor could it. Thus, when we look at the Forunzia trial chamber decision, tab 44, Authorities Bundle 3, tab 44, memory stick page 1361. These are the elements that the trial chamber extrapolated and used the Torture Convention as an interpretive guide to articulate. And then we see there...
Sorry, paragraph?
Paragraph 162, my lord.
Yes, thank you.
And these are this is the case where the ICTY sought to use UNCAT to set out elements of the crime when it thought there was a perpetrator requirement that it needed to apply within within the law of armed conflict, which it was applying in its statute. It turned to UNCAT to try and to identify what the elements should be, and these are the elements that the trial chamber in Forensia articulated, which were, as we've seen, later dropped by Kuneratz and later dropped altogether from international humanitarian law and crimes against humanity by the ICC statute. And the crucial element is element 5, which is over the page at memory stick page 1362, and in using the public official capacity requirement under UNCAT, this is the additional element that the ICTY inserted, that at least one of the persons involved in the torture process must be a public official or must at any rate act in a non-private capacity, e.g. as a de facto organ of state or any other authority-wielding entity. And as I say, that the ICTY was using UNCAT to articulate that element for the purposes of the crime that it was dealing with, namely a war crime under Article 3 of the statute, which, as the trial chamber specifically said, they were using the UNCAT definition to articulate a crime, the elements of the crime, for their use within the context being applied by the ICTY, and as we see at paragraph 162, it was only doing so for use within the context of international humanitarian law. As the ICTY said, they were extrapolating elements for the international criminal law relating to armed conflicts, which was, of course, the subject matter jurisdiction, which was before them.
And so requirement 5 is later dropped?
It's later dropped, my lord. It's later dropped in Kuneratz and dropped altogether at the ICTY because it was seen as obsolete and not required within the context of international humanitarian law. And as we looked at yesterday, entirely dropped altogether from the elements of crimes at the ICC and the elements of crimes for the International Criminal Court. The trial chamber was not with these elements seeking to redefine what constituted a public official or official capacity under UNCAT. As the appeals chamber in Kuneratz said, when considering the Forensia elements, which is at tab 47, A3, tab 47, memory stick page 1389, paragraph 147 at the very top of the page, the appeals chamber said this of the Forensia trial chamber decision with that element. The Torture Convention reflects customary international law as far as the obligation of states is concerned and must be distinguished from an assertion that this definition of the crime, this is the definition of the crime of torture generally. And as the Court of Appeal stated in this case, at memory stick page 230, paragraph 63, Forensia is not a sure guide to the construction of the Torture Convention because the case was decided at a time when it assumed there was a limited class of perpetrator for the purpose of international humanitarian crimes in times of armed conflict. And that's at paragraph 64 of the Court of Appeal's decision. That's all I propose to say about the ICTY jurisprudence. In relation to the US jurisprudence, again, rather than consider all the US jurisprudence which is set out in the appellant's written case, paragraphs 69 to 88, memory stick pages 83 to 87.
Sorry, paragraphs?
Paragraphs 69 to 88, my lord.
Thank you very much.
Memory stick pages 83 to 87. The starting point, we respectfully submit, is the report of the Senate Executive Committee on Foreign Relations on UNCAT, which is at A4 tab 67, memory stick page 1632. This is the report of the Senate Executive Committee on Foreign Relations recommending that the Senate give its advice and consent to the ratification of the Torture Convention by the United States. And at the bottom of memory stick page 1633, we see that the convention itself was the product of 7 years of intense negotiations in which the United States played an active part. At memory stick page 1645, we have the Senate Committee's consideration of Article 1 of the Convention. And memory stick page 1645, we see there that the committee stated the scope of the Convention is limited to torture inflicted with the instigation, consent or acquiescence of a public official or person acting in an official capacity. The committee stated, thus, the Convention applies only to torture that occurs in the context of governmental authority, excluding torture that occurs as a wholly private act, or in terms more familiar with US law, it applies to torture inflicted under colour of law. Now that report was cited in the case of US and Belfast, a universal jurisdiction prosecution under section 2340 of the US Torture Act, in which the US Appeals Court 11th Circuit at tab 73 MS 1885 stated, the Senate executive charged with evaluating the Convention Against Torture aptly explained that there is no distinction between the meaning of the phrases under colour of law and in an official capacity. The interveners have provided a US case, an extradition case of the United States and Mujugic. It's at Intervenor Bundle 1, tab 16, page 335. This was an extradition of someone from the United States to Bosnia and Herzegovina. The extraditee was said to have committed crimes in an official capacity during the Yugoslav conflict, in his capacity as a commander with the autonomous province of Western Bosnia, which was not a recognised state, but plainly had state-like qualities in the sense that it had a president, a permanent population, defined territory, it had a government and a capital, and the capacity to sign, and indeed did sign, peace agreements. If we look at, it's important to highlight that this is a first instance decision, Judge Peebles, and at footnote 18 on page 358, he explains that he had not been, the court had neither the BIA, the Bosnia and Herzegovina, the United States, nor Mugajic have provided the court with any guidance as to how the colour of law is defined or used in the context of section 2340A. He then goes on to cite the cases of Pitchell and Screws in the United States, and using the definition in those cases, says it is clear that Mugajic acted in official capacity and as APZB platoon commander and was not acting in the ambit of his personal pursuit when he allegedly captured, disarmed and interrogated Kordic, etc., and then beat, shot and killed them with the assistance of other APZ commanders.
So in that context, acting in an official capacity could extend to military activity?
Well, in his judgment, again, it's worth stressing that this is a first instance decision. It wasn't appealed, perhaps understandably, given that Mujagic was going to be extradited in any event for the unlawful killing, regardless of what the outcome of what his official capacity would or would not have been for his being extradited for torture. But we respectfully submit that has to be contrasted with the articulation of what constitutes colour of law in the US Supreme Court case of US and Price, which is set out at tab 74, Authorities Bundle A4, tab 74, memory stick page 1941,
Could you just give me the paragraph reference to the paragraph and the page reference, the paragraph
18 first.
that you read out just now?
Oh, the one that I was reading out from footnote 18, my lady.
From footnote 18?
Footnote 18, his analysis, Judge Peebles' analysis, that analysis I just read out is contained at footnote 18 of the
On
judgment.
On
Page
358.
358, my lord.
Footnote 15.
18, my lord. Page,
Quite right.
Page
Quite right.
358, footnote 18. Tab 74, memory stick page 1941, the US Supreme Court in Price stated private persons jointly engaged with state officials.
Sorry, which page?
Memory stick page 1941 at the top of the page, my lord. Private persons jointly engaged with state officials in the prohibited action are acting under colour of law for purposes of the statute. To act under colour of law does not require the accused to be an officer of the state. It is enough that he is a willful participant in joint activity with the state or its agents. And again, we would respectfully submit that makes crystal clear that they're acting under colour of law relates to acting with the state or agents of the state.
I don't know this case. Was there any question of there being anyone other than a state official as the other party to the actings?
The other parties were those who were acting with an agent of the state, and it was by virtue of their acting with the agent of the state that meant that those individuals were acting under colour of law. But the crucial element and the essential element was those individuals to be acting under colour of law, they had to be acting in concert with agents of the state. And in relation to official capacity, at 1942, the Supreme Court, reiterating Senate Relations Report. Oh no, sorry.
Thank you.
1942, the Supreme Court stated the fault lies not in the indictment, but in the district court's view that the statute requires that each offender be an official or that he act in an official capacity. And again, we respectfully submit that that goes back to and reiterates the Senate Relations Report, that official capacity and colour of law are one and the same and have the same meaning. So that's our submissions on the US jurisprudence. Now then, if I may, some concluding remarks. Article 31 of the Vienna Convention provides the rules of general interpretation of treaties. Treaties need to, in the first instance, be given their ordinary meaning, and also one needs to look at subsequent practice in the application of the treaty. We considered yesterday the subsequent practice, looking at the practice and decisions of the Committee Against Torture, the decisions of the courts of this country, particularly E&O, Medical Justice, Pinochet, Jones, and just now some of the state practice at the US. Now, if we may look at the object and purpose of UNCAT. As articulated in Burgess and Danielius, stressing again that Burgess was the former chair rapporteur of the working group looking at UNCAT, at A1 tab 19.
Mr. Danielius was also a member of the working group.
He was, and I think, I'm not sure whether at some other stage he was also a chair, but certainly he was also a member of the working group. But Burgess certainly was the chair rapporteur of the working group. Turning to A1 tab 19, memory stick page 496, and we looked at this yesterday. Just very briefly to deal with the bit that I didn't read out yesterday. It is expedient to address at the outset.
Sorry, page.
Memory stick page 496, my lord.
Thank you.
It is expedient to address at the outset a widespread misunderstanding as to the objective of UNCAT. Many people assume that the Convention's principal aim is to outlaw torture. It goes on. This assumption is not correct insofar as it would imply that the prohibition of these practices is established under international law by convention only. and this prohibition will be binding as a rule of international law only for those states which have become parties to the Convention. On the contrary, the Convention is based upon the recognition that the above-mentioned practices are already outlawed under international law. The principal aim of the Convention is to strengthen the existing prohibition of such practices by a number of supporting measures. And then they go on to articulate the section that we looked at yesterday, which provides that the Convention specifically does not deal with ill treatment which occurs in an exclusively non-governmental setting. It only relates to practices which occur under some sort of responsibility of public officials or those acting in an official capacity. At memory stick page 523, at the top of the page, Burgess and Donnelly state, memory stick page 523, the problem with which the Convention was meant to deal was that of torture in which the authorities of a country were themselves involved and in respect of which the machinery of investigation and prosecution might not therefore function normally. Thus, the object and purpose of the Convention was to deal with situations in which the authorities of a country did not or would not intervene because they were themselves involved in the abuse, namely state-sanctioned torture. And again, as stated by Burgess and Donnelly, the Convention does not deal with an exclusively non-governmental setting. The conduct of non-governmental or non-state actor groups, absent the consent or acquiescence of a state, does not fall within the scope or definition of Article 1. But that is not to say that the non-functioning of the machinery of investigation and prosecution is of irrelevance to the Convention. And I say that because of general comment number 2, which we looked at yesterday, but it's perhaps worth looking at again. In bundle A3, tab 55, at memory stick page 1473, paragraph 18, general comment number 2, as we noted yesterday, is in relation to the obligation of states parties pursuant to Article 2 to take effective measures to prevent and punish torture. And at paragraph 18, the Committee Against Torture state, where state authorities or others acting in an official capacity know or have reasonable grounds to believe that acts of torture are being committed by non-state officials or, and this is important, private actors, and they fail to exercise due diligence to prevent, investigate, prosecute and punish such non-state actors or private actors, consistently with the Convention, the state bears responsibility. Now, it will be noted that such state responsibility applies equally to a failure to exercise due diligence in relation to private actors in as much as it does to non-state officials. And we see at the end of paragraph 18 a reference to the committee having applied this principle to states parties' failures to prevent and protect victims from gender-based violence, such as rape, including domestic violence, which goes back to the example we considered yesterday, female genital mutilation and trafficking. Now, no one would suggest that perpetrators of domestic violence, by virtue of a state's failure to prevent, could fall within the scope of Article 1. Now, albeit of a different magnitude, we respectfully submit that exactly the same principle applies to the failure to exercise due diligence in relation to non-state officials who do not fall within the scope of Article 1. And you see that with all of the Committee Against Torture decisions that we looked at yesterday. That is how and why the Committee Against Torture, even though groups such as the LTTE, the Taliban, Sendero Luminoso, even though their actions and conduct do not fall within the scope of Article 1, the Committee is able to consider it because of the application and provision of due diligence. It's the failure to apply due diligence that makes the conduct of those groups fall within the scope of Article 1 and therefore put the Committee Against Torture in a position where it could consider it. But it's also important to draw a distinction between a state's failure to apply due diligence and a state that's not in a position or unable to act, because we respectfully submit that different considerations apply in relation to a state that is unable and a state that fails to, that is unwilling. There's a distinction between unwilling and unable. A state's inability to prevent or punish does not place the conduct of non-state actors within the scope of Article 1. And that's in direct contrast to a state that is unwilling to conduct due diligence. States plainly cannot be required to do the impossible. So in the civil war context, and even in situations when armed opposition groups occupy and control territory, the state is only expected to use and apply all available measures to prevent torture, such as protesting or conducting investigations. But it is the state's unwillingness to prevent, and it's the state's unwillingness to prosecute torture that turns a non-state actor's act into that transforms that to fall within the scope and purview of Article 1 of the Convention. And that's because unwillingness, when one looks at the scope of Article 1, unwillingness plainly translates to the state giving its consent or acquiescence to the torture carried out by non-state actors. It's that transforms the conduct of non-state actors into something that falls within the scope of Article 1. And it's the state being unwilling or unwilling to act in those circumstances that makes their conduct fall, and taking steps to address that. That is what falls within the object and purpose of the Convention.
Mr. Poles, I can see why, in circumstances where a state is unable to act, the conduct of rebels should not be attributable to the state for the purposes of state responsibility. What I'm unclear about at the moment is what bearing that has on what I think may be the distinct question as to the circumstances in which an individual is held liable under the Convention scheme.
An individual can only be held liable under the Convention scheme if they come under what was intended by Article 1 of the Convention, i.e. state actors, by virtue of being a public official or acting in an official capacity. Individuals, even in an individual capacity, acting for organisations or groups that do not fall within the scope of Article 1, just simply don't come under the Convention at all. They cannot be considered under the Convention in their own individual right.
Why should the scope of state responsibility be a limiting factor so far as the liability of individuals is concerned?
Because the individuals only fall within the scope of the Convention if the state it only comes under the definition of torture in Article 1 if the state has consented or acquiesced in the conduct of that individual. A state that's acting out with that regime doesn't even come into it at all. They don't fall within the scope of Article 1 in any way, shape or form.
Unless it's otherwise an official act. Well,
but official act, we respectfully submit, it plainly, from all the analysis that we've done already, plainly only relates to that carried out by a public official or someone acting in an official capacity for or on behalf of the state. And that is the whole thrust and the aim and objective of the Torture Convention. Now, that may come across as very, very harsh, and that may seem even illogical, but for better or worse, that is the regime that states created after 7 years of intense negotiation. We may not like it, we may want to unpick it, but for reasons that prevailed at the time, i.e. to create a regime to safeguard against state-sanctioned torture and combat impunity enjoyed by state officials, states negotiated and agreed upon the scope of the Convention as contained in Article 1. They could have, but didn't, gone for a broader scope. They could have, for example, if we look at tab 75 of Authority Bundle 4, they could have used the same formulation in the Genocide Convention. Memory stick page 1970. And if we see under the Genocide Convention, persons committing genocide or any other acts enumerated in Article 3 shall be punished whether they are constitutionally responsible rulers, public officials, or private individuals. I respectfully submit this maybe answers my Lord Lloyd Jones' question.
Sorry, which article were we?
Article 4.
Article 4, thank you.
The states could have opted to put private individuals and their actions within the scope of UNCAP, but they consciously didn't. They chose not to. And there are consequences as a result of that. And we're seeing the consequences here today. But that is what states chose to do. They could also have made Common Article 3 and Additional Protocol 2 of the Geneva Conventions applicable. That was even contemplated by the Swiss delegation. If we look at tab 11, bundle 1, back to the Travaux, memory stick page 329, sorry. The Swiss delegation noted, paragraph 42 at the bottom of the page, they even contemplated, they noted that the international regime under the Geneva Conventions and under the grave breaches provisions, subject to penal sanctions and under universal jurisdiction, they say at present these rules apply only to international armed conflicts. And the Swiss delegation stated it might be appropriate on the occasion of drawing up a convention against torture to extend this regime to all situations. This would be an important development in international law relating to criminal penalties. But of course, that isn't what happened, and the convention wasn't extended in that way. As a result of that, keen to ensure that the convention would be without prejudice to the Geneva Conventions and Additional Protocol 1 and Additional Protocol 2, we see at paragraph 56 on memory stick page 331 that the Swiss government proposes the introduction into the convention of a safeguard clause which combined with paragraph 2 would constitute a separate article concerning the material scope of this instrument. It's in section 2 there at the bottom of the page. The foregoing, they proposed inserting the foregoing is without prejudice to the provisions of the Geneva Conventions for the protection of war victims, as well as the additional protocol relating to the protection of victims of international armed conflicts and additional protocol relating to the protection of victims in non-international armed conflicts. Now that was ultimately encapsulated in Article 1(2) of the Convention, and we see above that at paragraph 55 the reason for that. Paragraph 55. The draft conventions against torture are more closely related to human rights regulations than to international humanitarian law applicable in armed conflicts. Care should therefore be taken to ensure that the future convention does not restrict the application of the latter in any way. Now, harsh as the regime may seem, that does not Article 1 does not prohibit states or bind states who want to provide greater protection. Article 1(2) of the Convention specifically provides that states may adopt national legislation of wider application. Now, some states have done that, and the respondent has very helpfully set out some of those states that have done that. So, at memory stick page 128, we see that Belgium, for example, has an extended provision that provides the application of torture to public officials within the meaning of this provision shall also be those who, in the event of the absence or default of the public authorities, are effectively acting as that's the Austrian
Austria.
Code. Sorry, that's my mistake. That's the Austrian Code. So the Austria has extended it. They've chosen to extend it, and they've done so. Belgium, at memory stick page 130, have done the same, an extended provision. Article 417 bis, in relation to anyone, relates to an officer or public official or bailee or law enforcement officer acting in the performance of his or her duties. And then, of course, there's a reference to public official or an individual. So again, Belgium has opted in its national legislation to provide for greater scope and greater protection, as has Turkey. Turkey is at memory stick page 131, and we see there that under the Turkish Code, Article 94, Turkey provides that the provision will apply to any civil servant, and subsection 4, any other person found to have participated in this offence shall be subject to the same punishment as the civil servant. So much, much wider than the scope as provided for under the Convention. But what's the position in the UK? Section 134, the UK plainly hasn't provided any greater scope or protection in terms of who Article 1 and Section 134 and the prohibition against torture, who it will apply to within the confines of the Convention. The UK has anchored and limited its statutory regime to go no further than that was adopted in UNCAT. And that perhaps is not surprising, given that during the negotiations, the UK preferred the state-centred approach and insisted on a state-centred approach, and as exemplified in the UK proposal, which we looked at yesterday, at memory stick page 349 at tab 12, the UK proposed inserting the language of or any other agent of state after public official. Now, if the UK wants to adopt a provision of wider protection, we respectfully submit that the way to do that is to amend the statute, to amend Section 134. But in the absence of that, understandable as the desire might be to push the boundaries, particularly with the aim of ending impunity for serious human rights violations, this must not be done at the expense of the rule of law and must not be done at the expense of the integrity of international law. As stated by Judge Sir Howard Morrison and Judge Professor van der Winkart in their separate but concurring opinion quashing the conviction for war crimes and crimes against humanity of Jean-Pierre Bemba at the International Criminal Court, and it's at A3 tab 41, memory stick page 1287, paragraph 5, ending impunity is only meaningful if it happens in full accordance with the values and principles that underpin the criminal justice process in an open and democratic society. But we would respectfully submit that whether such a drastic step need be taken as seeking to amend the statute without amending the statute, as noted by the respondent in their notice of objection to the appellant's application for permission to appeal, it's at memory stick page 30, paragraph 18, the answer to the proposed question that's before my lady and my lords today, the answer to the proposed question, i.e. the scope of official capacity in the respondent's view, will be relevant to a vanishingly small group of individuals. And we respectfully submit they're right about that, because with the passing of the ICC Act as amended by the Coroners and Justice Act 2009, taking examples that the intervener has very helpfully provided, the examples of the Taliban, Boko Haram, and ISIS, if any of them were to be resident within the UK, within the meaning of Section 70 of the Coroners and Justice Act, they could be prosecuted and could be held responsible, not just for torture, but any war crimes, crimes against humanity, and genocide. And they can be prosecuted here in the United Kingdom in the courts, criminal courts of this country. By ratifying the ICC statute, the UK has taken a decisive step towards ending impunity, such that amendment of Section 134 of the Criminal Justice Act may now no longer be necessary. Taking Zardad, for example, notwithstanding everything that we say about the incorrectness of the decision in Zardad, were he to have been in the UK after 2009 with the passage of the Coroners and Justice Act, he could have been prosecuted for torture under the ICC Act. There was a civil war in Afghanistan at the time of the alleged offences. It was an armed conflict, and he was here in the UK having claimed asylum. It therefore would have fallen within the scope of the International Criminal Court Act. Similarly, the allegations in this case, but for the timing that they occurred in 1990, therefore before the 1st of January 1991, they fall outside of the provisions and the protections in the International Criminal Court Act. But that is not, we respectfully submit, a reason to amend and extend the scope of Section 134 without amending Section 134 itself. Now, I see the time, and I wonder if I should stop.
Well, that's up to you, as we agreed earlier on. But you have had 47 minutes this morning, and so if you do the sums, you'll work out how long you're going to have in reply.
I think I'll stop there, my lady. Thank you very much.
Very well, thank you very much indeed. Ms. Eatwell? Mr. Perry.
May it please your lady and your lordships. The starting point is the overall objective of the convention, which is not in dispute. It was, as the preamble makes clear, to make more effective the struggle against torture throughout the world, and it was intended to be protective. The principal challenge for the working group and the draftsman was to identify those acts of torture of interest to the international community and properly to be characterized as an international crime. The debate was largely a debate between those states who favored the inclusion of private acts and those who did not. The distinction ultimately drawn was not between state and non-state conduct. That is not what Article 1 says, nor is it what Section 134 says. It was between official acts of torture, properly the concern of the international community, and acts of private individuals against other private individuals which are not. Official acts of torture may be committed by de jure as much as by de facto officials who are acting or purporting to act in an official capacity. So one convenient way of testing the arguments in any particular case is to ask the question, is the conduct we are examining conduct properly of concern to the international community? The assumption underpinning the convention is that torture committed as a criminal act by private individuals for private purposes will be a matter for the normal machinery of criminal justice within the municipal legal order. The convention proceeds on the basis that this assumption is likely to break down in the case of official torture, and thus it was drafted with the intention of dealing with those situations where national remedies were unlikely to be provided. Regrettably, this is all the more likely to be the case in a world in which increasing ideological, economic, and ethnic tensions have increased the risk of civil war, from Spain in 1936 to Syria in 2011, and where civilian populations are most likely to be at risk in fractured states. This is an area where a state-centered sovereignty approach has had to give way to the Convention's objective to protect individuals by deterring and punishing acts of official torture, that is, non-private torture, committed by those who purport to exercise government authority. Recognition is irrelevant. It would be irrelevant whether torture, Mr. Justice Treacy gave the example of China prior to 1947. In current international conditions, Northern Cyprus, whether a state is recognized is irrelevant.
What about the recognition of a government?
Or recognition of a government. This was one of the points made by Chief Judge Newman in the Kadich case in the United States. And he identified the paradox of denying recognition to the very state whose human rights conduct may be most questionable, would then have the effect of shielding that government from the reach of the convention.
But that's because the US has a particular policy on the recognition of foreign states, which other countries don't have, which is one of the problems with thinking recognition has got any great relevance to the current debate, because the United States refused to recognise all sorts of countries that the rest of the world recognises because they're clearly operating like states.
Yes. And Milady, what we say is that recognition is simply a distraction, because what you are, the key conceptual point we would submit is the conduct of interest to the international community, because that was where the line had to be drawn by the working group, and that was why there was the debate about private or public conduct. Now, on that basis, approaching the appellant's case, we submit that the conduct under consideration in this case was of a type that is of interest to the international community. It was not the conduct of a private individual acting against other private individuals for private purposes. It was properly characterized, and is properly to be characterized, if proved, of course, as official torture. So our submission is that non-state actors who seek to depose a government and who exercise de facto authority over a civilian population in the area in which they operate fall within both the scope of both Article 1 and Section 134. We submit that that is consistent with the wording of the provisions, which, as all the commentators acknowledge, extend beyond the concept of a de jure official. It is also consistent with the purpose of the Convention, and it provides a mechanism for prosecution wherever in the world torture takes place. It should not depend upon whether a rebel or insurgent group is successful, as in this case it was, or whether the insurgent or rebel group is unsuccessful and flees the particular territory, as all the case law and commentators also make clear, there should be no sanctuary for those who perpetrate torture.
Mr. Perry, do the rules of responsibility in states in international law have any bearing on the question we have to decide?
Well, my Lord, the short answer to that, my Lord, is we would submit no. But it is the case that Article 10, the rules on state responsibility, Article 10, which was considered by the Court of Appeal, what Article 10 says is if you're a successful revolutionary, then your acts from the beginning of the revolution or the insurgency become the acts of the official state. The way the Court of Appeal then analysed that was that that breaks down because we're talking about individual responsibility in this particular type of case, and therefore the analysis doesn't run in parallel. However, Lord, what I would say, Lord, is that it would seem odd if the situation depended upon whether your insurgency was successful or not. Because if your insurgency is successful, and the Court of Appeal questioned whether in fact it was a rule of customary international law even before draft Article 10 was promulgated, but clearly it was, because there were decisions of the United States Supreme Court in the 19th century dealing with insurgencies in Mexico, where it had been found that the acts of the insurgents were attributed to the state. But Lord, the reason why we hesitate to rely on that sort of submission is because of the individual nature of the responsibility under the Torture Convention as opposed to state responsibility, and also because it shouldn't depend upon whether the insurgency is successful or not. However, it does create this potential problem in as much as in this particular case where the insurgency was successful, Charles Taylor's government became the recognised government, and therefore all the acts committed by the de facto officials become the acts of the Liberian state. So that's a good indication of whether those acts were of interest to the international community. So the way that I would put it, Lord, is even if they don't have direct applicability, they do shed light on the question of whether this is properly something of interest to the international community.
My recollection is that there is, in the draft International Law Commission articles, there's a provision that says that the rules of state responsibility are without prejudice to the responsibility of individuals.
Yes, yes. Your Lordship is absolutely right. My Lord, we hadn't pursued the point in light of the Court of Appeal's analysis, but clearly the Court of Appeal was troubled by joining state or using state responsibility to make the connection with individual responsibility, and we see the force in that argument.
It would be very odd if the question whether an offence had been committed or not depended on whether the revolutionary group ultimately succeeded in replacing the government of the state or not.
Exactly, my Lord. And my Lord, there's another problem, or potential problem, when looking at the convention and what it means and the legislation on its face, because this type of situation with which we are concerned, the factual situation, is the very factual situation in which a civilian population is most likely to be at risk of torture. And the civilian population is most likely to be at risk of torture because of the very situation created by those who have initiated the civil commotion. And they are the very type of people who will seek to coerce the local population into submission, and the convention and its operation would clearly be defective if it did not apply in these types of situations. And although my learned friends use the example of a Cornish separatist group, there is no doubt that Cavaliers and Roundheads could have committed torture, and that Henry V would have been both a torturer and a war criminal. The position is that so far as this convention is concerned, while it may not apply to drugs lords, it applies to warlords, and the decision of the Court of Appeal was clearly correct for the reasons given. The approach for which we contend finds support in the decisions of the Committee Against Torture, most notably in the decisions in Elmi and SS and Netherlands. It finds support in the appellant's concession that the Convention applies in circumstances where there is a complete absence of any central government, which in itself we would respectfully submit is destructive of the appellant's case. And it finds support in the writings of the authors and academic commentators, most notably Burgers and Danelius, Nowak and MacArthur. And I'll take the court in a moment, if I may, to Professor Paolo Gaeta and also Professor Andrew Clapham. We also submit that although my learned friend's submission in relation to the decisions of the ICTY are absolutely correct, the decision of the trial court and the appeal court in Ferunzia, while we accept is of limited value, was not necessarily incorrect in what it had to say about de facto officials. And the position of the Court of Appeal also finds support in the case law of the United States, not only the extradition case of Mugajic, which is in the interveners bundle at Divider 16, but also the decision in Kadic. I'll take the court to it in a moment, if I may, but just for the court's note, it's at volume 4, Divider 69, at page 1699, and Chief Judge Newman was dealing with the colour of law requirement, and he concluded that it could be satisfied, and these are his words, by the mere semblance of official authority. It follows that on our submission, Zardad was correctly decided for the reasons given by Mr. Justice Tracy, and we also submit that Mr. Justice Tracy was correct not to impose Western standards of government when it came to considering whether the officials in question were de facto officials. As the court knows from our written arguments, see paragraphs 84 to 88 of our written case at pages 125 to 126 of the electronic record. We have invited the court to consider whether it is appropriate to provide guidance on the nature of governmental functions. And our submission is, for the purposes of Article 1 and Section 134, it is sufficient for the authority in question to purport to exercise some measure of public authority over a civilian population, such as military control, and that the authority need not be permanent, formal, or directly comparable to that of the state authority, if any, which it has replaced. In other words, we contend for an interpretation which is sufficiently flexible to take into account the fragile nature of the authority exercised by non-private actors in a divided state. And such an approach, we would submit, would be consistent with the Court of Appeal's recognition of the elements that elevate the conduct to a jus cogens of international law.
So how do you define non-private? How do you distinguish between private and non-private? You said earlier that the convention may not apply to drug lords, but it does apply to warlords. Now, drug lords also exercise authority over civilian populations in the areas where they are particularly active, in certain states at least.
I would agree. I said it may not apply, because if you were simply...
You did say may, I wrote down may.
Yes. But lady, what I would say in answer to you, the question is, a good indication is to look at the purposes in Article 1 for which the torture is taking place, because Article 1 is also trying to identify the purposes for which the severe treatment is being carried out. So you have obtaining information or a confession, or punishing the victim, or intimidating or coercing the victim or a third party, or some form of discrimination. Now, military control of an area would be sufficient in that public security is a paradigm function of government authority, and is also the situation most likely to be conducive to intimidation, coercion, and discrimination.
All of which would apply to purely domestic violence. All of it.
Well, if it is being carried out with a view to controlling the local population, imprisoning them, carrying out a function that would ordinarily be the function of the governmental authority, then we would submit that that would be sufficient. And it may be that that is the only way to enable the convention to operate in a way that is ensuring that conduct which is of interest to the international community is brought within its scope. But we accept that what has happened in the cases to date is that there has usually been an analysis of the type of factors that would be taken into account by the Committee Against Torture, for example, or by Mr. Justice Tracy in Zardad, where a number of features of the authority which is being carried out are identified. But we would submit that in a situation such as the facts of the present case, where you have military control of an area, that is going beyond a private act against by a private individual against by private individuals. in answer to the point that was raised yesterday as to the nature of the appeal and the facts and the division of functions, the division of labour, may I just sort of say something in relation to that? As your ladyship correctly noted, there are no facts that have been established in this case, and that is why we did not take any issue with the point taken by the appellant as the facts included in our written case. The facts are yet to be proved. They are, in fact, set out in two places. There's the judgment of the Court of Appeal at pages 166 to 167 of the electronic record, at paragraphs 3 to 4. And they're set out in more detail in the decision of Mr. Justice Sweeney at page 205 to 207. On the basis of the test as formulated by the Court of Appeal, and for that matter, the test formulated by Mr. Justice Sweeney, which the Court of Appeal said made no material difference, the respondent submits that assuming the prosecution witnesses come up to prove that test would in fact be, the test would be satisfied.
But the facts have gone beyond that now because of the potentially very significant paragraph 12 of the Statement of Facts and Issues, Mr. Perry.
Yes, I accept that.
Your further evidence, probably very properly disseminated after the Court of Appeal judgment, so we were told, saying that this was military control, very different from administrative control, just the occasional presence of fighters. Now, doesn't that alter the factual picture which the lower courts had?
Well, my Lord, 2 points in relation to that. My Lord, that's one aspect of the evidence, but my Lord, I accept that whatever this court has to say, it would then be a matter for the trial judge to decide whether the factual evidence taken at its highest is capable of satisfying any test, which would be a matter of law. And then if the trial judge concluded that the evidence was capable of amounting to, or of satisfying the test, the evidence would then be led, and it would be for the jury to decide the facts and be directed by the judge on what threshold had to be met before they could conclude, reach a conclusion of guilt.
But this is your expert. You're never going to be able to present any stronger case on official capacity than this. And if this isn't enough, then it's over.
Well, my Lord, may I say that, first of all, I'm not involved in the trial, but I'm told by my learned friends who prosecute that the position is that what is in the Statement of Facts and Issues is just one aspect of the evidence, and that will be a matter for argument in due course. The point wasn't taken here, my Lord, on the basis that the facts didn't really weren't so relevant to the issue of the certified question. But I accept, my Lord, that that's going to have to be looked at again if the appeal is dismissed and if the case goes back to the Crown Court. That will then be in play. But the position that we are in before this court is that the appeal is in relation to the certified question. If the certified question is answered in a way that is adverse to the appellant, then it would go back to the Crown Court for argument on whether the test is capable of being satisfied on the evidence. So I think that's the position, Lord, in relation to where we are.
Well, and if the appellant were to succeed in this appeal, does the case then still have to go back to the Crown Court for an amended interpretation of Article 1 to be applied to the Crown case on the facts?
Lord, if the court concludes that the appellant was not a person acting in an official capacity, then there is no case.
Well, quite, but we might not be able to reach, going around a bit in circles.
Yes, I see.
We might reach conclusions as to the nature of governmental activity, which are not exactly the same as either side's case.
Yes.
I think that's probably at the back of my Lord's mind.
Yes.
In which case, would it go back to the Crown Court for the evidence to be heard and tested?
Yes. And then it would be a question of law for the trial judge, based on anything the court had to say in relation to the test, to consider the detailed facts.
Yes. If this court were to accept the appellant's case in its entirety, that in effect it only applies to state action, or action in which the state has, or a state-like body has acquiesced, well, then the question would be whether the insurgent group was acting like a state in Liberia at the relevant time, or would you accept that there is absolutely no evidence to suggest that it was acting like a state? Forget recognition. But there's a difference between acting like a state and acting like a government. This is his point.
Yes.
And I keep banging on about it because it seems to me to be important.
Well, Lady, my view in relation to that is I think that would create difficulties for the prosecution. And I think the position would then be that the prosecution would have to take a view as to whether its case was at all viable, and if it decided that the case was not viable, then it would have to offer no evidence.
I suppose that might also apply to the intermediate conclusion as well.
It might also apply to any intermediate conclusion as well. The key question is whether, looking at the facts and taking them at their highest, could any test be satisfied? And if it could not, there is no case. If it could, then it would be left to the jury to determine in due course. So far as the Torture Convention and Section 134 are concerned, may I make these general points, just so that there is no doubt about it. First of all, we agree with the appellant that Section 134 is not of any wider application, but nor is it any narrower than Article 1. Second, we also agree with the appellant that the meaning of the words "any person acting in an official capacity" is the same under both Article 1 and Section 134. Where we part company is the ordinary meaning of the words "any person acting in an official capacity" in light of their object and purpose, and our submission, as the court knows, is that that is not limited to those acting on behalf of the government of a state.
But we noticed yesterday that in Section 134(1) there is a reference to the performance or purported performance of official duties. not purported official duties, but official duties, Mr. Perry, actual official duties. Does that not cast some, you say it's not narrower nor wider, okay. Does that reference to the need for official duties cast any light on what a person acting in an official capacity means?
My Lord, no. What purported performance of his official duties there is to avoid any suggestion that someone is saying that this was outside my official capacity. So that's what this is ensuring. You can't say it wasn't my official capacity, I wasn't acting in my official capacity, so it's making sure that there is no loophole here. This actually is consistent with the construction of a provision that is designed to provide the widest possible protection for people who may fall prey to de jure or de facto officials who engage in the repugnant practice of torture.
Do we know, is it narrated perhaps in the charges, or do we know otherwise what official duties Mrs. Taylor is said to have been performing?
Well, I'd have to sort of provide your lordship with the charges, but my lord,
This is an element of the offence.
Yes, the essential allegations are that what was being done was coercing the civilian population because of the ethnic differences that then existed in Liberia, and also in effect enabling the military officials who were under the command of the appellant to conduct their coercion of the civilian population. And it was overall as part of the assertion of control of the areas which gradually fell into the NPFL's territory as the central government lost control.
So where are the official duties within that presentation of the case?
Well, but Lord, the official duties are in the control of the areas where the appellant was asserting control, and also the imprisoning and dealing with the civilian population. And I think I'm grateful to Mr. Rogers who draws my attention to the summary in the Court of Appeal judgment, which is at the electronic page 214. So, for example, at paragraph 4, giving commands on behalf of the NPFL to NPFL soldiers who carried them out, and giving instructions to civilians.
Yes. The fact that she commands people to carry out acts of torture doesn't mean to say she's performing official duties. I don't know if it might be helpful for us to see the charges.
Well, my lord, I'll make sure your lordship has the charges, but my lord...
Are they basically properly summarised in paragraph 3.5 of the Court of Appeal's judgment?
I think that's taken from the prosecution case summary. And
Well, it would be helpful for
yes,
us in any event to see the choices.
there's also there's slightly more detail in Mr. Justice Sweeney's summary of the facts, which is at page 205 to 207.
Could you give me the paragraph number?
It's paragraph 28, and for example, at Little Roman 6, Little Roman 8, the control over the local civilian population, 10, Roman 10, 11, and Lord, may I just, in response to my Lord Reed's point, that of course one of the other considerations is that torture as an instrument of government policy, I mean that is part of that is one of the reasons why the convention is trying to ensure there is no immunity. So, and that of course underpinned the Pinochet decision. And when talking about official functions or official duties, it may be that someone is using torture simply as an instrument of government policy. And that in itself would not make it unofficial. And Pinochet deals with that. So if, for example, the appellant in this case was intimidating the local population as an instrument of government policy or an instrument to gain control of the particular territory, that would be the official duties or purported official duties. The purported official duties point is to meet the argument that was being run in Pinochet that torture couldn't ever be an official duty because it was so outrageous in terms of its conduct. And that is why it's constructed in the way that it is.
You said purported official duties. No, Mr. Perry. It's purported performance of
Purported performance.
official duties, actual official duties, I think.
Yes, your Lordship is absolutely right. So, so far as the convention is concerned...
Have you made your general points now, Mr. Perry, and you're now moving on to
I was yes.
detailed exposition thereof?
Well,
that might be a convenient moment for us to have a 5-minute break, given that it's a long morning for us.
Thank you very much, lady. Thank you. May I, without repeating the matters that my learned friend dealt with yesterday, make our submissions in relation to the travel? First of all, we agree with the analysis conducted by the Court of Appeal, which is page 177 to 178, paragraphs 37 to 46. And the points to note we would submit are as follows. First, the original draft of the convention prepared by Sweden was broadened to include acts committed by other persons acting in an official capacity. Second, the debate within the working group was largely between those states who favoured the inclusion of private acts, such as France, and those who did not. Third, the Federal Republic of Germany's proposal that it should be made clear that the term public official included those persons who in certain regions and in particular conditions actually hold and exercise authority over others, was clearly before the working group at the time that it considered the Austrian proposal, and the wording of the proposal by Austria, we would submit, achieved the same end. It broadened the concept of perpetrators. The fact that it was proposed by Austria, we submit, is of some significance given the way that Austria itself defines the offence in its own domestic law. See our written case at paragraph 26 at page 106 of the core volume, and also at page 128 where the provision appears. And while I accept the point, we accept the point that was made yesterday that section 312A is a 2013 provision, may I just explain why that was enacted in 2013? Prior to 2013, the Austrian government had contended that it did not need to enact a specific provision to reflect Article 1 of the Convention because, in fact, its own domestic law provisions covered all circumstances in which torture would take place. And so Section 312A was the Austrian government's first and only attempt to enact Article 1 of the Convention into its domestic law. So we submit that it does have some significance. So far as the preparatory materials are concerned, may I just make some short points in relation to the materials without necessarily going to all of the materials, but first of all, there is the Commission on Human Rights summary of the 19th of December 1978, which is at Volume 1 of the Authorities, Divider 11, page 322, which gives some of the background, and if I may just try to summarize it. First, the General Assembly had requested the Commission to draw up a convention on torture in December 1977. That's paragraph 1. Second, Sweden had prepared a draft which in its original form was limited to torture inflicted by or at the instigation of a public official. That's paragraph 7 on page 323, and the draft article itself appears at page 326. The reason for the inclusion of the public official point is made clear at paragraph 29 at page 327, which was to dispel fears of international criminal law encroaching on traditionally domestic concerns. And this point was key to the drafting of the convention, because there were two dimensions to this issue. One was it would not be of interest to the international community, or it should not be of interest to the international community, to trespass on traditionally domestic concerns. So it was to identify what was of interest to the international community, but also the other dimension was the international community did have an interest where the ordinary machinery of prosecution would break down. We can see from the early discussions, for example, paragraph 31 at page 328, that some states, such as France, considered that torture should be prohibited irrespective of the identity of the perpetrator. The French considered that it was the intrinsic nature of the act that should be determinative, and it was in those circumstances that Austria believed that the concept should be expanded. That's paragraph 43 at page 330. Divider 12 is the Commission on Human Rights summary of information received by the 18th of January 1979. So we've moved on from December 1978 to January 1979, and this contains the United Kingdom's proposal or any other agent of the state. That's at page 349, and then divider 13, the report of the 31st of January 1979, which contains Germany's proposal at page 353 at paragraph 2. For the court's information, we have provided an additional bundle with some other materials were located. I hope the court has been provided with a small additional bundle with three dividers. The first, this is keeping it in chronological order, having dealt
Sorry,
with...
Mr. Perry, I'm sure it's my fault.
Sorry.
This one that's on the bench.
Sorry.
Thank you very much.
So keeping it in chronological order, divider 11, divider 12, divider 13, and then, but in this little clip, there is the 12th of March 1979, which is the report of the working group, and the relevant paragraphs are, first of all, paragraph 16 on page 4 of the report, because we have proceeded on to the revised drafts, and in paragraph 16 is the revised Swedish draft with public official or other person acting in an official capacity. Then there was a version proposed by the International Commission of Jurists, and the court will see paragraph 1 with the consent or acquiescence of a public official or other person acting in an official capacity. Paragraph 17, there is a discussion of the draft, the first attempt to define torture. Definition should not be restricted to public officials. it was proposed that the convention should be made applicable to all individuals under the jurisdiction of a contracting state. It was said that such an approach was preferable because of the possible incidence of acts of torture committed by those other than public officials. By contrast, the view was expressed that such acts should be covered by existing or future national law, and international action was primarily designed to cover situations where national action was otherwise least likely. So there is the national action least likely point. And then at 18, it was generally agreed that the definition of acts committed by public officials should be expanded to cover acts committed by or at the instigation of or with the consent or acquiescence of a public official or any other person acting in an official capacity. And then paragraph 23, the proposed revision of Article 1 contained, and that reference there is to the Swedish draft, and the next reference is to the International Commission of Jurists drafts, was designed to satisfy those delegates who sought a broad definition of torture, which covered both public and private individuals, as well as to clearly restrict the coverage of the Convention to acts of torture falling within the scope of paragraph 1 of the revision. And that it's not necessary to look at the remainder. Then the next point in chronological sequence is actually behind divider 3 of this bundle, which is the 18th of December 1979, and page 45 at the bottom, there's a comment on the original draft. Barbados would have liked, page 45, under Article, the heading Article 1, Barbados would have liked the definition to be extended to cover the acts of private individuals.
Sorry, we're on page 40.
45 at the bottom, my lord, and it's page 3 at the top.
Certainly goes up
Page
to
3 of the report, sorry.
See.
Page 3 of the report at the top. And it's the third page in this behind divider.
paragraph.
Paragraph 9.
Thank you.
Under the heading Article 1. And then by the 5th of March 1980, it's divider 3, I'm sorry.
Sorry, got it then.
And then behind divider 2 is the 5th of March 1980, and this is simply to demonstrate that by the 5th of March 1980, Article 1 in its amended form had been adopted, and that can be demonstrated by page 3 of the report at the top, paragraph 10.
So what are we getting out of these, Mr. Perry?
But it's simply to complete the material in relation to the Travo.
I see.
And it fills in the blanks in the material that we haven't seen to date. It deals with the breakdown of the domestic machinery and the private-public divide.
Thank you.
It's still there. And your lordships and my lady were taken to the other materials yesterday. In support of our submissions, we rely on the discussion of the Travo in Burgers and Danelius. That's divider 19, electronic page 492 at 514 to 515 and 522 to 523, which the court was referred to yesterday, and Nowak and MacArthur, divider 24, page 597, that paragraph 118, which deals with rebel groups, insurgents, situations of civil war. There is also support for what is said by those authors in the writings of other commentators, and as the court has not been referred to these matters, may I invite the court's attention to Volume 1, Divider 20, electronic page 528, which is the late Professor Cassese's International Criminal Law. It's at Divider 20, and this is a discussion on torture as a discrete crime at page 532. And the court will see in the second paragraph on that page the need, the sentence begins, the need for this sort of participation of a de jure or de facto state official, and then stems from, one, the fact that in this case torture is punishable under international rules, even when it constitutes a single or sporadic episode. And two, the need to distinguish between an ordinary crime, such as the torture of a former intimate partner by a sadist is the example given, and torture as an international crime covered by international rules on human rights. So the authors are acknowledging the de facto state official falling within the convention, and it goes on to deal with the fact that it can create puzzles, and there's a discussion in some of the American cases. There is a reference to Ferunzia, and the court can see that there is also a discussion at the foot of the page about the US Court of Appeals decision in Philataga, where it had been stated that the torturer has become like the pirate or the slave trader before him, the common enemy of mankind. And reference to Ferunzia is to the quote from the decision, going over to 533 at the top, no legal loopholes have been left. There is also, in this same volume, Divider 23, at page 558, the discussion of the involvement of state officials by Professor Gator, and at 558 to 560, she discusses official torture and private torture. And the point that is being made here is the conduct that is elevated into the international crime is what she calls, at page 559 in the middle of the page, she says the state official requirement constitutes what one could term the something extra, transforming an ordinary criminal offence into an international crime. It simply serves the purpose of precluding every single wicked act carried out by private individuals against other private individuals from being elevated to the international level. So there is the dividing line that is distinguishing between that which is not of concern to the international community and that which is. And we can also see that Professor Gator and Professor Clapham support the decision in Zardad. This is in Divider 21 of this bundle at page, it begins at page 540. It's an exchange sorry, it begins at 535. It's an exchange of emails.
Sorry, what was your page number?
535.
535.
535. And it's an exchange of emails about torture by private actors and what is called gold plating the offence in national law. And they're actually an exchange of emails in honour of William Sharbas. And the relevant section for the purposes of the current issue appear at page 540, which is Professor Clapham's exchange to Professor Gator. And at page 540, he refers to, the convention uses the expression, it's about 7 or 8 lines down from the top, the convention uses the expression official capacity in contrast to state official. As you know, in the Zardad case, this was interpreted to cover a person working against the state as part of a rebellion. One could not say that the state acquiesced, yet the defendant was convicted and sentenced to 20 years. The judge said in Afghanistan there may be different types of structures which may come within the ambit of an authority. It seems that one can have torture by an authority even where that authority is fighting against the state. I admit this is just one case, but as we know, it's more likely that prosecutions will be brought for international crimes. And that then brings the response from Professor Gator at 541, where she addresses in the second paragraph of her response the discrete crime. And the way she puts it is, in the past, she's already expressed the view that the pure privatization of the crime would risk trivializing the offense of the international community into the realm of criminal law by taking into account every single instance of wicked conduct of an entirely private nature. And then she deals with the fact that what you can expect in the domestic systems, and at the bottom of the page she talks about her additional ingredient of what it is that transforms the ordinary criminal offence. And then on page 542, in the first main paragraph, I'm ready, however, to accept the view there's an expansion of the notion of public official or person acting in an official capacity to include those who exercise quasi-state authority would be fitting. I would, however, definitively exclude from the definition of torture acts by private individuals for private ends. More difficult would be to define whether acts of members of criminal gangs and other non-state actors not exercising quasi-state authority over a territory would qualify as torture without running counter to the principle of fair labelling. She hasn't made up her mind in relation to that.
Mr. Perry, when she talks about an expansion of the notion, is she talking about gold plating, or is she talking about the scope of the offence under the Convention?
She's talking there about the position under the Convention, because she's accepting that the correctness of the decision in Zardad. The point that she is making, my Lord, as I read it, is the only thing you definitively exclude is purely private, because to use her words, that's trivializing the acts that, and what takes it up into the international plane is the official the requirement for official conduct, not state conduct, but some form of de facto conduct. I think, in fact, in Professor Casase's textbook, that section which talked about de facto public officials, it looks as though it was actually written by Professor Gator, who's one of the editors of the late Professor's. And then it's Professor Clapham who says at the end of these email exchanges, does it really matter on page 543 whether it's performed by a warlord or a drug lord? But we would submit that where you have, as the Committee Against Torture has recognised, as Zardad recognised, where you have warlords at any rate, and they are exercising quasi-state authority, then that falls squarely within the Convention. It's not the purely private act, which is what Professor Gator is discussing. So there is support in the writings of the authors for the approach adopted by the Court of Appeal. I ought to just note that there is it's right to acknowledge that Professor O'Keefe at Volume 1, Divider 27, is doubtful of the decision in Elmi and even more doubtful of the decision in Zardad. That's at page 655 at paragraph 7.121, where he mentions the decision in Elmi being distinguished in HMHI in Australia. And at the top of page 656, he says that the exceptional, notwithstanding what the committee reiterated was the exceptional situation in Elmi, the committee's view is open to doubt. Even more doubtful is the ruling of the English criminal case in Zardad, that even where there exists a government within a state, the expression of public official or other person acting in an official capacity in Article 1 can extend to people who are acting for an entity which has acquired de facto effective control. The point that we would make in relation to that is, first of all, it's unreasoned, and second, it's difficult to understand the basis of the objection. It's difficult to understand why criticism is made of the committee for its decision declining to return the claimant in Elmi to Somalia, where he would have faced a risk of torture at the hands of warring factions. And as a principle, we would submit that the conclusion in Elmi must be correct, as is the decision in SS and the Netherlands. May I just make some submissions? I've now dealt with the writers, the authors.
Before we leave them, I don't want to take up a lot of time debating what academic writers are saying, but so far as Professor Gator is concerned, I think on page 542, when she speaks about expansion of the notion of public official to include those who exercise quasi-state authority, I think she's developing a point that she's made earlier on page MS 538, which introduces this discussion, where she begins by saying that, well, the question is whether states that opt for a criminalisation of torture should incorporate into their national law the requirement of the involvement of a state official mentioned in Article 1. And that's consistent with her own textbook, which is at 553,
Yes.
where that's her understanding of what the Convention Article 1 means. But then she goes on to say that national jurisdictions can expand that under Article 1, Paragraph 2, which allows for a wider definition of torture in national law. And I think that may be the context in which she says she's ready to accept the view that an expansion to include those who exercise quasi-state authority would be fitting.
Yes. Lord, what I would say in relation to that is, so far as Professor Clapham is concerned, he's making the point that it was a convention.
He's on the other side of the fence, clearly.
It was a convention interpretation that was being adopted. Now, what Professor Gator, what I would submit, Lord, is the fundamental point that she was making is the true division is the private-public divide, not state, not state actor. It was public-private. Does it have a public dimension that then elevates it to the international sphere? And I would submit that that's consistent with everything you see in the writings of the authors, whether it's the paragraph 118 of Nowak, the Federal Republic of Germany, and it applies to rebel states, that it's all consistent, we would submit.
Before we leave the academic material, I'm rather assuming that there have not been any published commentaries on the decisions of either Mr. Justice Sweeney or the Court of Appeal in this case.
My lady, no, and it may be because of the reporting.
The certified question.
It may be because of the reporting restrictions, which have limited.
Suppose so, yes. Yes.
Which have limited their.
Yes, there's not a lot you can say about it.
Their circulation, as far as we're aware, there have been no further discussions.
Mr. Perry, just one further question on the writers. It's said against you that Nowak and MacArthur got it wrong when they said that it was the West German concerns which gave rise to the Austrian Amendment.
Well, and
touched on this morning.
Yes, but, my Lord, it was also acknowledged by my friend that he couldn't exclude the fact that when it was the reason I produced the additional material this morning was to show that it was in March 1980 that particular article was adopted, which was after the Federal Republic of Germany had put forward its proposal, and it was after the Austrians had put forward their proposal. So it cannot be excluded, as my learned friend fairly acknowledged yesterday, that it was part of the compromise to deal with, on the one hand, the Federal Republic's concerns, and on the other hand, those who wanted it to go to the private side because of the intrinsic nature of the Act. So, my Lord, whatever one makes of the commentary and the chronological sequence, the point that is made is still a good one in the academic writing and in that particular paragraph, paragraph 118.
Thank you very much.
So far as the decisions of the Committee Against Torture are concerned, may I just make some brief submissions in relation to those? There are, in effect, 6 relevant decisions that begin in 1998 with GRB and Sweden and end with SS and Netherlands in 2003. Our key submission is that the combined effect of ELMI and Australia, ELMI is Divider 48, page 1390, and SS and the Netherlands, which is Divider 43, page 1457, is that the convention cannot be limited to state actors. In ELMI, it was accepted that the convention was not limited to entities tolerated by or acting under the authority of a government of a state. And although reliance was placed on the fact that state authority was wholly lacking, that cannot be, we would submit, a principled distinction for confining the operation of the convention, and it would not serve the purposes of the convention to limit it to a state where there was no functioning government. And indeed, in SS and the Netherlands, it was the occupation of territory coupled with control that was the determining factor, although in that case the applicant was returned because it was possible to return him first of all to Kenya, and he could be returned safely to Somalia. Once it is accepted that the convention applies in the circumstances of ELMI and SS and the Netherlands, then there is no reason in principle to distinguish a situation which a rebel group occupies territory even where central government continues to exercise control over other parts of the contested territory. That is also consistent with the other decisions of the committee, and without going to them, I just make these points. First of all, GRB and Sweden, which is Divider 49, page 1405, which was the Peruvian national claiming the risk of torture at the hands of the Shining Path. The points to note: first, there was no finding in that case, or there appears to be no finding, that the Shining Path were in control of any territory. Certainly there was no finding that it was a group exercising any governmental functions, and there was also the possibility of internal flight. The position in SV in Canada, which is Divider 54, page 1454, which was the return to Sri Lanka and the LTTE, the Tamil Tigers, there appears to have been no basis in that case for believing that the LTTE were exercising quasi-governmental authority over an area to which the claimant would be returned. And it makes perfect sense if you can be returned to an area where the government is under an obligation not to torture and also to prevent your torture, then the threshold of a substantial risk is not satisfied. MPS in Australia, Divider 52, page 1433, another case involving Sri Lanka, and the Australian government in that case argued that he'd failed to demonstrate that the LTTE were exercising quasi-governmental authority over an area to which he would be returned, and the committee held that there are no substantial grounds to demonstrate a foreseeable risk. That's at 1439, see in particular paragraph 7.4 to 7.5. There is one point, if I may, just to make in relation to HMHI and Australia, which is Divider 50, page 1415, And this was another case involving Somalia, in which the Australian government sought to distinguish the earlier decision in Elmi. And at page 1421, it's perhaps just a small point, but in paragraph 6.4, there's reference to GRB in Sweden, and it states the committee considered that allegations of a risk of torture at the hands of Sendero Luminoso as a non-state entity controlling significant portions of Peru. It is not apparent from GRB in Sweden that there was any finding of controlling significant portions of Peru. It's not clear precisely where that comes from, unless I've got that wrong. But what appears to be the test that's developed through the committee is if it is an entity that does exercise some territorial control, and where it does purport to carry out functions of a governmental nature, then that can be taken into account, which would be consistent with the protection that the Convention is intended to provide. So those are our submissions in relation to the committee's decisions. So far as the domestic authorities are concerned, I'm not going to deal with them in any detail, but if I may just make some points. There are three criminal cases and one civil case. The three criminal cases are Pinochet, Divider 33, page 860, Lama, Divider 36, page 1096, which was a decision of the Court of Appeal, Lady Justice Hallett presiding, but which my Lord Lloyd-Jones was a party, and Zardad, which is Divider 38, page 1181. Those are the three domestic criminal cases. There is also one domestic civil case, the Jones case, in relation to Saudi Arabia, in which it was held that the Convention did not provide a basis for a cause of action overriding state immunity for torture committed in Saudi Arabia. However, so for present purposes, Pinochet, we would submit, is important because of the discussions concerning the development of international criminal law and the concept of personal liability. Although it did not address the current issue, and its ratio is limited, there are valuable insights on the development of international law, customary international law, in the opinions of Lord Brown Wilkinson at page 901 to 903 and 910 to 914, Lord Hope at 956 to 961.
Sorry,
Lord Hope 956 to 961. Lord Millett in particular at 987 to 988, and Lord Phillips at 1001 to 1003. And the point, just trying to summarize, is the movement towards a less centered, state-centered approach to liability following 1945 the development of the concept of individual liability and the interests of the international community in eradicating repugnant practices such as torture, which are to be ranked in the way that piracy and slave trading are ranked, as being of interest to the international community, which is more responsive to the individual rights of citizens of all states. The decision in Lama, Divided 36-1096, doesn't address any of the issues currently before the court, and it's not necessarily referred to it. It's just noted as a decision in this jurisdiction. But the decision in Zardad is most relevant. It was the first case of its kind under English law. Zardad was a general in charge of the Sorobi area of Afghanistan, with around 1,000 men under his command. And the central government did not control the region, and the defendant was the only law enforcement authority in that area. If I may just turn to the decision which is at Divider 28, at, sorry, 38, I'm sorry, Divider 38 at 1181, 1181. And the essential reasoning begins at page 1182, and paragraph 6 is section 134 and article 1, and the reason for the public official requirement, and the distinction between private acts. There is reference to the decision in Elmi at paragraph 16, and HMHI also paragraph 16. And there is also reference to Ferunzia, paragraph 24, and reference at paragraph 26 to ingredient 5 as identified by the tribunal in Ferunzia. And at paragraph 27 is the extract from the decision of the United States Court of Appeal of the Second Circuit in the case of Kadich. And the court will see, I'll come to Kadich in a moment if I may, just to look at the decision, but the court will see that the 2 points are being made in that extract from Kadich. The first is in relation to recognition. And the second point, in the final 6 lines of the indented passage, it's likely that the state action concept, where applicable for some violations like official torture, requires merely the semblance of official authority. The inquiry, after all, is whether a person purporting to wield official power has exceeded internationally recognized standards of civilized conduct, not whether statehood in all its formal aspects exists. And that then led to the submissions that we see at paragraph 28 on behalf of the prosecution, the semblance of official authority, part of an authority wielding entity with exclusive de facto power in that area, and acting in a non-private capacity. And the position in relation to the facts. They're summarised at paragraph 31. And the judge says there's sufficient evidence to show the following, and it's effectively the military control point. And the conclusions are at 33, where it was being argued that because there was a central government in Kabul with a recognised ambassador to the United Nations, that was not conclusive, and the judge makes reference to communist China prior to its recognition, and he deals with sufficient control, and he also makes the point about not imposing Western-style type concepts when considering what a government authority might look like. And at 38, he sets out his conclusions de facto officials, and he says at the concluding part of 38, to adopt the construction contended for the defence would leave a substantial loophole in the enforcement of an international obligation, and in the attempt to penalise the international crime of torture where it's committed by those who are in authority, either under the force of the law or who are in reality in authority as a result of a situation which has come about or which they have created. And we would submit that that is correct. The convention was intended to work, and it was intended to work coherently, and it would not work coherently if, for example, to use an illustration used by the Court of Appeal, if a general of a rebel army in the same territory as a general of the state army carried out exactly the same conduct against civilians, and one was caught by the convention but one was not, that would be capricious rather than rational. And we would submit that that was not the intention created by the drafters of the convention or the working group. So far as the decisions of the ICTY are concerned, I've finished now with Zardat. The Court of Appeal dealt with the decisions at paragraphs 59 to 64 of the judgment at page 181 to 183, and we respectfully agree, although we simply make this point that in Ferunzia, which is page 1354, paragraph 146, and page 1361 for paragraph 162, when the tribunal was purporting to apply customary international law, and it spoke of a de facto official acting on behalf of an entity, we submit that that was doing no more than identifying the reach of what the convention was intended to achieve in any event. And while it's right to acknowledge that the later case law, notably in Kunarich, to which the court was taken, page 1388 to 1389, the ICTY abandoned the official capacity requirement for torture as a war crime. We would invite the court to take into account the earlier analysis of what the tribunal took to be the customary international law principles and the importance it attached to the reach of the convention and what was said to be the no loopholes point, which is cited in the academic commentaries. So far as the United States authorities are concerned, I don't intend to deal with the United States authorities in any detail. I can summarize the effect of the authorities. In the main, they are civil claims for damages under the Alien Tort Statute of 1976, which was the successor to the Judiciary Act of 1779, and also there are claims under the Federal Tort Claims Act. The only point to be made is, and this is the point I'm going to make when I referred to some of these authorities, the only point to be made is that the analysis in Kadich cited by Mr. Justice Tracy has not been disapproved of or overruled, and it is still being cited as relevant to the colour of law requirement as a matter of US law.
Well, Justice Newman is very rarely overruled, if at all, and frequently cited.
Yes, and that's even the case, my lady, in the most recent, the Belfast case, which was which came from Liberia. They cite Judge Newman's analysis in Kadich as explaining the content of the colour of law requirement. That is why, when my learned friend referred to the extradition authority and said it's a first instance decision, in fact, it is all consistent with what Judge Newman was saying in the Kadich and Karadzic case. The dispute that I'm not going to sort of dwell on these points because there isn't anything that addresses expressly this issue, and the authorities don't shed light on the state actor point. There's the Hannock Tel Oren decision, which is Divider 72 at page 1789. That's the Israeli citizen survivors and representatives of persons murdered in an armed attack on a civilian bus in Israel. And the US courts held that they had no jurisdiction, although the judges reached their conclusions on very different grounds. But it's effectively, it's equivalent in some respects to the Jones decision here. No civil claim in the United States under the old under the Alien Tort Statute. Kadich it was decided in 1995, and again, without turning it up, but it's at page 1699. And the discussion of offences of universal concern, including those capable of being committed by non-state actors, is at page 1703. The discussion in relation to torture begins at 1707, and see in particular the quote we've already seen at 1708 to 1709. In Sousa, the decision of the Supreme Court, the only reason for going to this decision is that it's at divider 71, and it's at page 1744, and the only purpose of going to this decision is that in footnote 20 to Mr. Justice Souter's opinion for the court, in footnote 20, there is reference to Kadich without any suggestion that it was wrong. It was simply comparing the conclusion with that had been reached in the Tel Oren case. That is also the position that was also made clear in the Ali Shafi decision, which is divider 68, page 1676, which noted the Kadich decision at 1686. That was these were all civil cases, and Shafi is applying the cautious standard mandated by the Supreme Court in the Sousa decision. The Belfast decision is the criminal, apart from the extradition case, the only criminal case. It's divider 73, page 1847. And at page 1886, reference is made to the very, perhaps I can just turn to that, because the court was referred to United States and Price, which was the murders in Mississippi during the 1960s. But in at 1886, when in Belfast it's talking about under colour of law, it discusses the concept, and it talks about possessed of state law, and then it refers to West and Atkins, and at 1886, see also Kadich, looking to the 1983 colour of law jurisprudence for guidance on whether a defendant engaged in official action under the Alien Tort Statute. And of course that was Judge Newman talking about the semblance of authority point, because it was, what is it that is, what are you actually addressing here? And it's the fact that you are addressing what is a serious criminal offence by someone purporting to act in an official capacity. And so, although the United States authorities don't address the precise issue, there is some support in Kadich, and also there is the civil case of Vukovic, which is divider 70 at page 1718, and at 1729 to 1730, it was, these were various civil claims brought by refugees in respect of acts of brutality in Bosnia. The court relied on the de facto government authority of the Republic of Srpska. It's fair to say that it also relied on the fact that the Republic had the support of Serbian authorities, but it did take into account the de facto government authority. So our submission on the basis of the authorities is that the Convention and Section 134 go beyond the ordinary concept of public official to include de facto officials. That is supported by the academic commentators and the Committee Against Torture. It is also supported by the decisions such as Kadich looking at the reality of the situation, and Zardad also looking at the reality of the situation, which properly gives effect to the object and purpose of the convention. Any other interpretation we would submit would lead to a situation that was manifestly unreasonable or absurd within the meaning of the Vienna Convention. The appellant's conduct was not private conduct carried out for private purposes. It was conduct carried out as an instrument of de facto government power in support of an attempt to take control of a territory, and we would invite the court to dismiss the appeal, confirm the correctness of the decision of the Court of Appeal, and if the court felt able to provide guidance on the nature of governmental functions, then that would no doubt assist the parties in the future conduct of the trial. May I finally just mention the trial date, just so that the trial date is currently the 7th of October, and I'm not suggesting that there should be a judgment before then, but Milady, the point is that many of the witnesses have to be brought to the United Kingdom, and visas have to be arranged. And if that trial date is simply not viable, it would be of great assistance to the parties to know that sooner rather than later. And I simply mention that so that the court is aware of the situation.
Well, thank you, Mr. Perry. That's extremely helpful for us to know that. There are, of course, many ways in which we can make our judgments known to the big wide world, and we're even capable of doing this while the court is not actually sitting. So we will discuss, of course, what we think a realistic timetable will be, but we will bear very much in mind the point you've just made.
Thank you very much.
You've got your sleeve is being tugged.
Yes, I'm told it's 6 weeks to organise visas and matters of that nature.
6 weeks, yes.
But
well, that's helpful. We can count back from from the 7th of October to see you.
Milady, I hope I've covered everything. I adopt what we say in our written submissions also. Unless I can assist the court further, those would be the submissions on behalf of the respondent.
Could I just raise one point, which was prompted by your manifestly unreasonable or absurd point to reach any different conclusion? It's said against you that quite a lot of the examples raised by you and by the intervener are in any event covered by the International Criminal Court statute or by ad hoc tribunals like the ICTY. But I'm assuming that you would say in response to that, but their coverage is extremely patchy. It's not anything like as universal as the coverage of UNCAT, to which a very large number of members of the United Nations are party, whereas the Criminal Tribunal for former Yugoslavia was, of course, ad hoc for that particular situation, and the ICC's jurisdiction in relation to war crimes and genocide is obviously very partial, depends upon its being accepted by the state in question, which they can sometimes do, and they can sometimes withdraw it, and all sorts of things go on. So it's a very different state of affairs. Now, am I putting words into your mouth, or?
Well, the answer to that is yes, but I can also develop the point, because the point being made is absolutely correct. And first of all, it raises points in relation to the Torture Convention. There are over 160 signatories to the convention at the moment, and it is expected by 2025 that every recognised state in the world will be a signatory to that convention. But its reach doesn't depend upon whether you're a state party to it, because the obligation, and this raises the point that my lady made this morning about extradition, it's not just an extradition point. You can prosecute in the United Kingdom for torture committed anywhere in the world, whether it was committed in the territory of a state party or not, and whether it was committed in the course of an internal conflict or in the course of an international conflict. And it doesn't matter under the convention whether it takes place in a recognised state or not. The difficulty with the point about, take first of all the International Criminal Court. Many states don't recognise the International Criminal Court, and therefore they won't submit to its jurisdiction. So immediately there's a problem. The other problem is that there aren't the same obligations in international law under the Rome Statute. There is an obligation of cooperation, but there is not an obligation to extradite to the Rome Statute. And as the Court of Appeal noted in the circumstances of this particular case, the Torture Convention applies it may apply in circumstances where there is no armed conflict at all, but for months and months and months, or years it may be, there is a de facto authority in a particular territory, and there would be an incentive and a deterrent on any officials in that de facto authority from acting in contravention of the obligations under the convention, because the objective is to eradicate torture wherever in the world it may take place, and by giving it the reach that the drafters obviously intended, we would submit, and as all the commentators support, furthers that objective. So, and so we would say that you can't achieve the same objective through the ICTY, which in any event is being wound down, or the Rome Statute, but you can do it through the convention.
Mm. Thank you very much indeed.
I had a question. Would you like me to put it to him after the short adjournment?
How about putting it now?
Fine. Mr. Perry, I'm not sure you've dealt with medical justice, have you? I'm not sure you've dealt with the detention services order, which quotes the UNCAT definition of torture,
yes,
and then adds,
yes,
this includes acts carried out by terrorist groups exploiting civil war to hold territory. And Mr. Justice Owsley observed that that wasn't part of the definition of UNCAT, but had been added in. Yes. Did you want to say anything briefly about that?
Lord, I can deal with it briefly, Lord. The point that we would make, Lord, first of all, this precise issue isn't being addressed. This precise issue raised by the certified question was not being addressed by the court. The second point, Lord, is that when you're talking about terrorist organisations that may be vying for control of territory, that in itself raises questions about de facto authority, because the problem with terrorist organizations is that is a matter that the international community does have sensitivity about for obvious political reasons. The point that I would make, Lord, is that those Home Office guidelines were enacted for a specific purpose, to cater for a specific problem, and there isn't a complete convergence between the issue in this case or what we have there, because they don't talk about terrorist groups that have control of territory.
But the point about those Home Office guidelines is surely they were to deal with people who, because of their history, should not be detained, unless it's absolutely essential. And their history may come from all sorts of sources, which would nevertheless make them unsuitable people to be detained. So it's difficult to get too much assistance.
Well, that's clearly the point of it all, but I'm not sure that really deals with Mr. Powell's point.
Well, Lord, it is a different context.
It is.
It is a different question that's being addressed. And this point in relation to de facto authority is not something that was confronted by the court, because they didn't have to confront it in those cases. They have their own tailor-made definition. But, Lord, in the criminal context, when you look at the materials that we have, that we would submit, the message is consistent.
Very well. Thank you very much indeed, Mr. Perry.
Mr. Perry, what we will do is we'll adjourn now. We will not treat you as having sat down in case any of my colleagues have got any further questions they wish to put to you, which occur to them over the short adjournment. But it occurs to me now that we've made such good time that there's no need for us to sit early because we have got the intervener and we have your reply, and you've already eaten substantially into your reply, so we're going to be finished long before 3 o'clock in any event. So
3:30.
No, we are going to be finished long before 3 o'clock.
3 o'clock.
Because we've only got half an hour of the intervener,
yes.
and then we've got Mr. Powell's abbreviated reply. So we're going to be finished long before 3 o'clock, so we'll come back at 2 o'clock.
Thank you very much, Lady. Thank you.